Well, I'd like to welcome you all here today. I'm Michelle Easton, the president of the Claire Booth Luce Center for Conservative Women. Today we are so happy to be hosting the freedom-loving, tyranny-hating lawyer, policy analyst, and podcast host, Gayle Trotter. Gayle gave a great talk for us not too long ago at our Conservative Women's Network lunch that we sponsor every month with the Heritage Foundation. She's going to be introduced separately, but I just have to say she is an amazing professional and a proud parent with her husband of 6 children, 2 of whom are already out of college. Joining me today to introduce our speaker is one of our summer interns, Hope Timmel. She's from Maryland. Hope is a rising senior at the University of Maryland, Baltimore County, majoring in media and communication studies. Here at the Luce Center for Conservative Women, we are so happy to have Hope with us for the summer. Hope?
Thank you for joining us today as we host Gayle Trotter. Gayle is a co-founder of Schaefer and Trotter PLC, a law firm in metropolitan Washington, D.C. that advises entrepreneurs and small businesses. She received an undergraduate degree in government from the University of Virginia, where she obtained a law degree as well and served on the editorial board of the Virginia Journal of International Law. She has a podcast called The Gayle Trotter Show right in D.C., where she provides conservative analysis and thoughts about current news and politics. She regularly appears on TV news programs. Gayle has been published throughout the D.C. political scene and often appears as a guest on national radio. She and her husband are the proud parents of 6 children and make their home in Washington, D.C. Today, Gayle will be speaking on a woman's right to choose protection. In this talk, Gayle will give an overview of the history, meaning, and purpose of the Second Amendment, as well as the truth about the impact that private gun ownership has on public safety. Gayle will also expose how ideology and bias distorts the issues in this important debate. Please join me in welcoming Gayle Trotter.
Thank you so much for inviting me to join you today. I am so excited to be with you, and I'm so impressed by your commitment to learn about the conservative movement and work this summer as interns. I can really relate to you at your age. I not only have daughters who are around your age, but I also remember very strongly being your age. And I feel like the challenges are so much more so now for you young women than it was when I was your age. And I thought it was difficult then, but it's only become increasingly more difficult. So I want to thank Hope so much for introducing me, and I'm so excited that you're at University of Maryland. That's a family school for my family too, so good luck to you, and great that you're studying media and communications. And I want to share with you about my experiences with the Second Amendment. So I am not an expert on gun rights. I'm a lawyer, and I'm a mother of 6, and I'm someone who cares very deeply about safety and protecting vulnerable people. So I started writing about the Second Amendment right before there was a major hearing in the United States Senate. So this talk that I'm going to give you today is a little bit about my experiences testifying before the Senate Judiciary Committee in 2013, which you might remember was the first hearing that the Senate held after the Newtown massacre, which was so upsetting and riveting to the entire country. And I am a lawyer, so I do care very strongly about the Bill of Rights, and I want to share with you some things that you might not know about the Second Amendment and our Bill of Rights. And I also want to talk to you about how the media interprets the Second Amendment. So you know you've hit a nerve with the mainstream media when the New York Times uses its lead editorial to scold your ideas for being dangerous. This is the same newspaper, mind you, that takes pride in publishing military and state secrets when they feel it's politically expedient to do so. Just another ironic day at the office for the old gray lady. The truth is, the Times and other liberal elites were shocked shocked to see a Washington, D.C. lawyer and mother of 6 tell members of the United States Senate that guns are the great equalizer for women, and consequently, that newly proposed gun control measures that they were pushing at that time would have a disparate impact on women. The big government liberal elites especially took offense when I said that millions of American women want their legislators to safeguard a woman's right to choose to exercise her Second Amendment rights to protect herself. A woman's ability to arm herself for her protection is even more consequential than for a man because guns are the great equalizer in a violent confrontation. We preserve meaningful protection for women by safeguarding our Second Amendment rights, and lawful self-defense is a central component of the Second Amendment. For its first hearing of 2013, the Senate Judiciary Committee convened to discuss a question: what should America do about gun violence? And if you've been following the news this week, you'll see all of the violence that's gone on in Democrat-controlled cities like Chicago is boiling over into the mainstream media. They can't not cover it. And so you can see that this is a topic that has persisted throughout the entire history of our country, but it's yet again, it flares up periodically over time. So this is another time that we're seeing way more attacks on our Second Amendment rights. So we all want a safer society, right? People differ, though, on whether a particular proposal may increase public safety in a nation where private owners already have 300 million guns. Here's my answer. First, what America should do is to preserve and protect our Bill of Rights. Second, what America should not do is pursue bad policies based on fear-mongering and demagoguery. Third, we should not allow our legislators to engage in self-defeating gestures that sound attractive, but they have perverse effects. Our political leaders should reject proposals that will not only fail to make Americans safer, but will harm women the most. The truth is that women can and often do use firearms to defend themselves and others against violent attacks. In this talk, I'm going to cover 3 points. First, some observations about the history, the meaning, and the purpose of our Second Amendment. Second, the facts about private gun ownership and public safety. And third, observations about the role of ideology and bias in this debate. Now, for some reason, the anti-gun crowd conveniently overlooks the fact that the Second Amendment is part of our Bill of Rights. We all know how big government liberals like their judges to invent new rights that appear nowhere in the Constitution. Their euphemism for this practice is to say that the Constitution is a living document, but that's just hype. There are parts of the Constitution that they want to kill. For those provisions, big government liberals want their judges to make parts of the Constitution disappear without a trace and airbrush them out of history. There is no better example of this than the Second Amendment. Like it or not, armed citizens founded this nation, and we just celebrated this last weekend. And when they did, the founders enshrined gun ownership among the civil liberties enumerated, listed, numbered in the Bill of Rights. Yet for opponents of the Second Amendment, the right to keep and bear arms is an embarrassing oddity, a quirky anachronism that they might grudgingly concede, if pressed, applied to flintlock muskets. History dispels this myth. From the outset, the Second Amendment existed to protect citizens against tyranny by ensuring the right to gun ownership. And as Michelle introduced me, I'm a liberty-loving, tyranny-hating mother of 6, and so this is really critical for me, and this is why I'm so passionate about this topic. From the outset, as I said, the Second Amendment existed to protect citizens against tyranny by ensuring their right to gun ownership. Alexander Hamilton, whom you might be familiar with, said that an armed citizenry is the best and only real defense against forces of tyranny, writing in Federalist 29 that the best possible security against a standing army is a large body of citizens, little at all inferior to them in discipline and the use of arms, who stand ready to defend their own rights and those of their fellow citizens. James Madison said the people have ultimate authority and would develop plans of resistance in response to ambitious encroachments of the federal government. Does that sound familiar to anyone? He observed in Federalist 46 that the free and gallant citizens of America, unlike the people of almost every other country, have the advantage of being armed. Now, as a result, the Second Amendment guarantees to the people, the right to keep and bear arms. Unlike other individual rights, this one appears in the Constitution's literal text. The Bill of Rights guarantees a right of the people only 2 other times, both of which times clearly describe individual rights. The First Amendment protects the right of the people to assemble and to petition the government. And the Fourth Amendment protects the right of the people against unreasonable searches and seizures. In lieu of empty, self-defeating gestures, we should address gun violence by doing what works. By safeguarding our Second Amendment rights, we preserve meaningful protection for women. Our nation made significant progress in that regard when, in recent memory, in 2008, the Supreme Court held that the Second Amendment protects an individual's right to possess a firearm for traditionally lawful purposes, such as self-defense within the home. First, the court held in 2008, in a case called D.C. versus Heller, that the Second Amendment guarantees an individual right to possess a firearm unconnected with service in the militia. And I'm going to repeat that, unconnected to service in a militia, because we hear that a lot as an argument against the Second Amendment individual right to self-defense. But the Supreme Court held you have an individual right for self-defense unconnected to service in the militia. And you can use that firearm for traditionally lawful purposes, such as self-defense within the home. Now, in a parallel case 2 years later, the Supreme Court held that this right applies to the states and not just the federal government. Now, for those of you who believe in safeguarding the civil liberties enshrined in our Bill of Rights, you might consider this unremarkable. The constitutional text expressly guarantees the right to keep and bear arms, and that right is specifically enumerated, not implied, and guaranteed to the people. In other words, unlike so many of the individual rights that the Supreme Court has recognized, some people would say invented, you can actually find the right to bear arms in the literal text of the Second Amendment. Moreover, the Constitution guarantees a right of the people only 2 other times, both of which times clearly describe individual rights. Again, the First Amendment protects the right of the people to assemble and to petition the government. The Fourth Amendment protects the right of the people against unreasonable searches and seizures. That was not enough for the liberal dissenters in these cases. They decried the, quote, court's announcement of a new constitutional right to own and use firearms for private purposes, end quote. Ironically, this claim originated from those who agree with the judicial philosophy that has discovered new fundamental individual rights hiding within penumbras that emanate from specific guarantees of the Bill of Rights. Now, adherents to this view, and I'm not making this up, they maintain that the Bill of Rights generates penumbral emanations that create assorted individual rights. Even so, they simultaneously claim that enforcing an individual right expressly written in the black letter of the constitutional text is the announcement of a new constitutional right. Well, let's see here. Shadowy secretions reveal the hidden meanings of rights secretly embedded in the Constitution and just awaiting judicial divination. But a specifically enumerated constitutional guarantee in the Bill of Rights is a new constitutional right. Okay, got it. But wait, there's more. The dissenting justices claimed that a local law can ban private possession of any form of operable firearm because, well, the adjacent states do permit the use of handguns for target practice, and those states are only a brief subway ride away. They called this a minimal burden on the Second Amendment right to bear arms, as if a law-abiding citizen who is confronted by a violent attacker might somehow have the ability to coax the attacker onto a subway and go to the jurisdiction that allows target practice. Unbelievable. So here's a judicial philosophy for you that purports to allow restrictions on individual liberties as long as there's a brief subway ride away that would transport an aggrieved individual to another jurisdiction where the rights are not similarly restricted. It's not hard to imagine that these same judges would require greater protection of the rights that they invented, the ones that form from penumbral emanations. Now, all of this is quite far afield from where our founding fathers were. Now remember, the advantage of being armed, Madison said, is one that Americans possess over the people of every other nation. And the best possible security against a police state, according to Hamilton, is a large body of citizens ready to defend their own rights and those of their fellow citizens. Now, the divide between the conservative and the liberal Supreme Court justices shows us two dramatically different views of our Bill of Rights. One approach has repeatedly created new rights found nowhere in the Constitution, while unflinchingly limiting the Second Amendment's right of the people to keep and bear arms to protect only the right to have a gun in the Army, as vacuous as that would be. The other approach, which twice has prevailed in the Supreme Court, takes seriously the people's enumerated rights, the ones actually written in the Constitution, and upholds the Second Amendment rather than airbrushing it out of our Constitution. Now, with this in mind, let's turn to the facts about private gun ownership and public safety. Considering the compelling story of Sarah Mckinley, and I'll just give you a little background about why this story is so compelling to me. We had a rash of mass shootings leading up to this Senate hearing in 2013, and I kept wanting to write something about it because I had something I wanted to say, but I couldn't quite find the way that I wanted to express it. And then I read the story about this young mother, Sarah Mckinley, who was a teenage woman whose husband had recently died, and she had a baby with her. And I thought, oh my gosh, this encapsulates exactly what I believe about our fundamental Second Amendment rights. So let me tell you the story of Sarah Mckinley. She was home alone with her baby, and she called 911 when two violent intruders began to break down her front door. The men wanted to force their way into her home so they could steal the prescription medication of her deceased husband, who had recently died of cancer. So imagine that, being in this home with your baby, your husband has just died, and there are two men banging on the door trying to get into your house. And they are up to no good, right? So she's on the phone with 911, and before the police could arrive, while Mckinley was still on the line with the 911 operator, these violent intruders broke down her door. One of the men was brandishing a foot-long hunting knife, and as the intruders forced their way into her home, Mckinley fired her weapon, fatally wounding one of the violent attackers, which caused the other one to flee. And later, Sarah Mckinley reflected on the incident, and she said it was either going to be him or my son, and it wasn't going to be my son. And just as a mom, I just could so put myself in her shoes and understand the fear and the stress. And nobody ever wants to be in that situation, but unfortunately, you can't predict it. So from that story, it is clear that guns make women safer. And it's an uncomfortable fact for opponents of the Second Amendment. Guns reverse the balance of power in a violent confrontation. This is especially the case because I don't know if you know this, if you've ever heard this before, but over 90% of violent crimes occur in the United States without a firearm being involved. And this is according to the Department of Justice Bureau of Justice Statistics. Now, how do guns give women the advantage in a violent confrontation? Armed with a gun, a woman can have an advantage over a violent attacker. An armed woman does not need superior strength or the proximity of hand-to-hand struggle. She can protect her children. She can protect the elderly relatives she might have. She can protect herself, and she can protect others who are vulnerable to attack. She can use a firearm with a magazine holding more than 10 rounds. We hear this a lot. There's a lot of effort by liberals and leftists to try and limit the amount of capacity you have in a firearm. And yet the real issue is who is wielding the firearm, not the capacity of the magazine or the clip itself. And so if she's using a firearm with more than 10 rounds of ammunition, a woman would have a fighting chance against even multiple attackers. Now, concealed carry laws help to reverse the balance of power even before a violent confrontation occurs. For a would-be criminal, concealed carry laws dramatically increase the risk of committing a crime because the criminals can't tell who's carrying and who is not, which potential victims can defend themselves. So for a potential victim, carrying a gun enhances the ability to defend oneself and others from a violent attack. Now, these two effects, they indirectly benefit even those who don't carry, with demonstrable results on crime rates, as documented by economist John Lott. And if you're not familiar with John Lott, I recommend you look him up online, and he's got excellent data and responses for a lot of these issues as they come up, and I find his information very informative for me as well. So John Lott, L-O-T-T. For example, among the 10 states that adopted concealed carry laws over a 15-year period, there were 0.89 shooting deaths and injuries per 100,000 people, and it's less than half of the 2.09 per 100,000 experienced in states that did not adopt such laws. So you adopt concealed carry laws, and it goes down by half. So that is a dramatic result just from having the laws. And not everybody has to conceal carry, but everyone benefits from concealed carry. So in my Senate testimony, I provided a detailed summary of recent news accounts selected from the last 12 months, so that would be 2012. Each of these accounts involves women like Sarah Mckinley who used a firearm to protect herself or her loved one against violent men. The examples included a woman who defended herself against 5 burglars, a woman who thwarted an attempted shooting at a school, a woman who saved her child from a kidnapper, a woman who stopped a gunman in a movie theater, and 18 other examples of women using firearms in self-defense. These types of news accounts almost never gain national attention, despite their prevalence. Private citizens, and this is an important fact, private citizens account for more than 1/3 of all instances where a violent criminal is killed during the commission of a felony, according to a Justice Department study on U.S. homicide trends. And this is a really important fact to keep in your head. Americans use firearms defensively 2.2 million to 2.5 million times a year, according to a study by criminologist Gary Kleck, based on a sample of which women accounted for 46% of instances of defensive firearm use. Now, Gary Kleck is no ideologue on this issue, considering that he describes himself as a member of the ACLU, a lifelong registered Democrat, and a contributor to liberal Democrat candidates. You're never going to hear those statistics from the mainstream media, so let me repeat them just one more time. The Justice Department says that private citizens account for more than 1/3 of all instances where a violent criminal is killed during the commission of a felony. And Gary Kleck, card-carrying ACLU member, calculates up to 2.5 million instances of defensive gun use annually by private citizens. Now, research has found that reduced gun ownership results in increased home invasions and lethality of attack on law-abiding citizens. John Lott's research shows that homeowners who defend themselves make burglars generally wary of breaking into homes. Kind of makes sense, right? If you're going to get some kind of resistance, you're less likely to want to take that risk. Similar to the concealed carry phenomenon, that creates spillover effects, or what economists call external benefits, from the fact that in both cases, criminals can't know who's armed. Now, during the Senate hearing, Senator Chuck Grassley asked me why a semi-automatic rifle such as an AR-15 has value as a weapon of self-defense. Why does it have value as a weapon of self-defense? I responded that AR-15 rifles are accurate, they have good handling, they are light, and they are easy for women to hold. And yes, I highlighted their scary-looking appearance. Now, just a few days after that, a New York Times report on the AR-15 cited similar benefits, calling the rifle fast, modern, ergonomically designed, and relatively easy to handle, noting that it produces little recoil and highlighting its appearance as something commandos might carry. Now, when the Supreme Court held that the Second Amendment guarantees an individual right to possess a firearm for traditionally lawful purposes, such as self-defense within the home, the court indicated that the right covers weapons that are typically possessed by law-abiding citizens for lawful purposes. Now, the AR-15 satisfies that standard, considering that Americans own over 3 million of them. Now, at no point did the Supreme Court suggest that citizens are limited only to weapons that would provide a merely adequate ability to protect their families. That's the standard that Senator Sheldon Whitehouse suggested, an adequate ability. Now, meanwhile, gun rights opponents continue to cite many discredited studies to claim that private gun ownership does more harm than good. You might have heard one by Arthur Kellerman of Emory University. He used data gathered from homicide victims' relatives who were asked if the deceased owned a gun in the home. Now, the study gave the misleading impression that the same gun had been used in the homicide. And in fact, if you look back in the data, of the 444 homicides studied in his 1993 paper, only 8 deaths out of 444 involved a gun that had been kept in the house. Now, Kellerman himself reported that most of the deaths did not even involve a firearm at all, with the majority resulting from a knife or some sharp instrument, that was 26.4%, victims bludgeoned, 11.7%, strangled, 6.4%, or other means, 5.7%. So most of them didn't even involve a firearm at all. Kellerman's research counted a benefit from defensive gun use only where a criminal had been killed or injured, ignoring the fact, and this is a really important fact to remember and keep in your head as well, that violent attackers, are killed or injured in less than 1% of defensive gun use. Now, this is just one example, but the list goes on and on. A detailed and scholarly feminist critique of gun control by Inga Larish concluded that gun control proponents They ignore statistical evidence of actual civilian gun use and fail to reduce violent crime against women. So this is a liberal feminist critique of the liberal view of gun control. So Larisha's study concluded that gun control measures disproportionately harm women by restricting or removing the most effective method of self-defense available from a feminist perspective. So it's very interesting. Now, we know that armed security works. That's why brave men and women stand guard over banks, airports, rock concerts, and government buildings. Snipers stand guard on the White House roof. Politicians and other high-profile individuals, including prominent gun control activists, they have been shown to have gun permits either currently or in the past. Now, while armed security works, gun bans do not. Anti-gun legislation keeps guns away from the law-abiding and the sane, but it doesn't keep guns out of the hands of criminals. Nearly all mass shootings have occurred in gun-free zones. Law-abiding citizens do not bring firearms into the gun-free zones, so psychotic killers know that they can inflict more harm in these unprotected environments. These laws make easy targets of the sane and the law-abiding. Gun control advocates cheer the creation of legally mandated gun-free zones. They tout increased safety, but actually they make citizens in these locations more vulnerable. And they're more vulnerable to the next horrible monster in search of a soft target. A moment's reflection confirms that statutory provisions and bold signs do not create a gun-free environment. No sober-minded person would advocate that approach when protecting banks, airports, rock concerts, and government buildings. Instead, publicly designated gun-free zones have the effect of creating high-visibility soft targets, conspicuous environments where maniacs can wreak havoc. We need sensible enforcement of the gun laws that are already on the books. Currently, we have more than 20,000 under-enforced or selectively enforced gun laws. Gun regulation affects only the guns of the law-abiding. Criminals are not bound by these gestures, especially as we continually fail to prosecute serious gun violations or provide meaningful and consistent penalties for violent felons involving firearms. This brings me to my third and my final point, the role of ideology and bias in the gun debate. Politicians and celebrities want to prevent law-abiding citizens from using guns to protect themselves, but they feel entitled to claim that privilege for themselves. Consider the fact that armed guards often serve in the employ of those who themselves advocate for more restrictions on gun rights. George Clooney. Politicians continue to seek to restrict our gun rights. Now, Hollywood actors somberly urge Americans to demand a plan to reduce gun violence, despite their own roles in graphically depicting lethal violence on the movie screens. In both instances, many of these politicians and celebrities already have their own plan to reduce the threat of gun violence in their own lives. They rely on guns to protect their own personal safety. It's all too typical for gun rights critics themselves to face exposure for relying on firearms for their own personal protection. For example, armed guards protected a suburban newspaper in New York after the newspaper published the names and residential addresses of gun permit holders. Can you imagine? Separately, the newspaper's own reporter who did that story was shown to use a gun for his protection. After publishing the story, the editors disclosed that their reporter owns a Smith & Wesson and has a residence permit in New York City. Very cute. Medical politicians like to sound the alarm about the dangers of guns. And I'm talking about doctors who are always on the not all doctors, obviously, but the ones who are pushing for more gun control restrictions. So these people these doctors do not like to recognize that many more people die each year from physicians' negligence than die from firearms. The medical literature on gun control generally betrays its own anti-gun bias. Analyzing the claims of Kellerman and others, Edgar Suter, a physician, has documented wholesale faulty methodologies, false citations, fabricated data, overt mendacity in all the medical literature on guns, finding a remarkable failure of peer review. Suter's expose cited a Harvard study finding that physicians' negligence kills annually 3 to 5 times as many Americans as guns. 3 to 5 times as guns. Based on that study, Suter concluded that with sad irony, it has become vogue for medical politicians to claim that guns, rather than medical negligence, have become a public health emergency. The phrase, "physician, heal thyself," comes to mind. Now, reminiscent of reporting on shark attacks, media coverage has much more to do with sensationalism than real-world danger. For example, residential swimming pools are far more dangerous to children than firearms. Reams of research have found that reduced gun ownership results in increased criminal home invasions and lethality of attack on law-abiding citizens. Economist Stephen Levitt wrote in his best-selling book, Freakonomics, that the likelihood of death by pool, 1 in 11,000, versus death by gun, 1 in 1 million plus, it isn't even close. Levitt calculated that a child is roughly 100 times more likely to die in a swimming accident at a house with a pool than in gunplay at a house with a firearm. Gun regulations in the District of Columbia, my hometown, are an absurd state. You might not remember this, but David Gregory used to host a show, and he inadvertently demonstrated how absurd DC gun laws and enforcement of DC gun laws is when he was the host of that show. He displayed a 30-round magazine on national television and thereby embroiled himself in a police investigation, because you can't have that in DC. And he had it and showed it, evidence right there. He's showing it on television. They know where the studio is. Ultimately, the DC Attorney General decided not to prosecute David Gregory. Quote, "Despite the clarity of the violation of this important law," the DC Attorney General said, he concluded a prosecution would not promote public safety. Why is it permissible to possess magazines to persuade people that guns are dangerous, but not for a woman in DC to possess one to defend herself against home invasion or gang rape? Overbroad anti-gun regulations unduly increase prosecutorial discretion and result in selective enforcement of the law. Equal justice under the law should not depend on whether a prosecutor has a political or ideological motivation to seek enforcement. Nor should justice depend on whether a prosecutor has the good sense to decline enforcement of a knowing violation that does nothing more than unwittingly demonstrate the law's absurdity and overbreadth. Now, millions of women care deeply about their Second Amendment rights. We want to protect a woman's right to choose to protect herself and her loved ones from violent attackers. To paraphrase James Madison, the free and gallant women of America, unlike the people of almost every other nation, have the advantage of being armed. Those who care about women's well-being should work to safeguard our right to keep and bear those types of firearms, typically possessed by law-abiding citizens, to protect ourselves and our families, because nearly all violent crimes occur without firearms, making guns the great equalizer for women defending against violent attacks. Guns make women safer. The Supreme Court has recognized that the lawful self-defense is a central component of our Second Amendment's guarantee of the right to keep and bear arms. For women, the ability to arm ourselves for our protection is even more consequential than for men because guns are the great equalizer in a violent confrontation. As a result, we preserve meaningful protection for women by safeguarding our Second Amendment rights. Every woman deserves a fighting chance. Thank you very much. And I think now I can take questions. Yes. So any questions? Yes, Julie.
It seems like everything that you were saying goes on equal justice, prosecutors, judges, lawyers, media. There's so much in culture that impacts this issue. What do you think the best strategy for us is, culture-wise, to actually protect the Second Amendment?
I did a Clubhouse. I found that Clubhouse is like the new thing. So I was trying to recruit conservatives to come and talk to me on Clubhouse because it's sort of dominated by the left, apparently. And I reached out to Erin Murphy, who is a Second Amendment lawyer at Kirkland. And I reached out to Amy Schwerer at the Heritage Foundation. I asked them to come on Clubhouse, and we discussed this very question that you asked. Now, the Supreme Court has a case that it's going to hear in the new term with the new justices on a lot of these issues, and it will be interesting to see what the decision of the Supreme Court is. But we cannot, and as a lawyer, I say this over and over again, we cannot rely on the Supreme Court to vindicate our rights. They hear a very tiny number of cases, like 100 or less every year, and it's not enough to expect the Supreme Court to constantly bat down laws that are an infringement on our Second Amendment right to defend ourselves. So in talking with Amy and Erin, I thought Amy made a great point that the best way we can do it is exercise our right. So I recommend that all women get training and go get, in Virginia, I don't know where all of you live, but in Virginia, you can apply for a concealed carry permit once you hit a certain age. And I think it's something that we have this right that we can exercise, and we shouldn't let it go without a fight. And I think the more people who get training, and some states you don't need a permit for concealed carry, but the more we take advantage of our rights, the more we care about them. And even though, as I said in my talk, that we all benefit if there are private citizens willing to do this, I think it's it's a benefit that most people in most countries don't have. So I think we change the law by changing the culture and by having more women, and the numbers have gone up very high of women who are really taking up exercising this right. So that is my answer. Yes. What is your name?
Marley.
Oh, Marley. Nice to meet you.
Nice to meet you. What would you say about questions when it comes to carrying guns on college campuses? I know my college, I attend Hillsdale, and we're allowed to bring them, but check them into the security office or the gun range. But campuses that aren't allowed to have them at all, or safety in regards to that.
That is an excellent question, and that's something that really impacts so many college students around the country. I've forgotten the woman's name, but I think she spoke at one of your lunches, and I came and heard her speak, but it's a horrible story. I feel bad even relating it because it's not my story or my experience, but she was, I believe, raped on a college campus in a parking lot, and the college wouldn't let her carry to protect herself. I don't remember if the guy got loose or there was some story where she had a specific reason why she wanted to defend herself. And she is and I've forgotten her name off the top of my head, but she's a really strong speaker. So I would, Amber, if you look her up and listen to her story, I'm sure it's probably linked on your website somewhere. And it was a really different way of looking at it, and I found her testimony very, very compelling. But related to what I was just talking about, you might remember I was talking about gun-free zones and how the law-abiding do abide by those restrictions, but putting little signs and laws, criminal people aren't going to abide it. So I don't know if you remember the Virginia Tech episode, but that was a, huge slaughter of students by someone who was not entitled to have a gun on the campus and had all sorts of red flags that the people didn't notice or didn't act on. Didn't stop him. So I think it would be great if college students made these cases, and through your student council, through the administration, and not in a aggressive way, but just, this doesn't make sense. Like, we're here at college, we're learning, and we need to be safe. And putting up signs is not going to protect us. So I think that is a great question. But I recommend you look at Amber's speech to this organization. Yes, what is your name?
Caroline.
Caroline, nice to meet you.
So a couple weeks ago, President Biden made the comment, this kind of goes back to protection against government tyranny, about like, oh, well, you would need F-15s to actually defend yourself. So what would be your response to that comment?
I'm so glad you asked that. And that was great on Twitter. I just enjoyed watching everybody change their bios to, F-15 connoisseur, and I love when Democrats say ridiculous things and they get roasted for it. So that goes back to my explanation of law to you. So the Supreme Court held up the view of the individual right of the Second Amendment was held up in D.C. versus Heller in 2008, and then in 2010 it applied to the states, and specifically the court holding said that firearms traditionally held for lawful purpose. No one wants an F-15. So that just says they are losing on the logical part of the argument, so they go to the crazy, absurd response to it. So like AR-15s, that's been a big discussion, and you might not be familiar with this, but there was an assault weapons ban. I think it was in 1994 it started. And they did research, I think it was for 10 years, they did research to see if it helped limit gun violence. And it didn't. So the Congress did not put the assault weapons, the so-called assault weapons, back into place because it was opposed from the beginning, but then they couldn't show any evidence that it actually reduced gun violence. And you hear this over and over again by the Democrats. They want to try the same things over and over again. And when you have 20,000 laws that are not already being enforced and that are just used for political motivations, you might remember that couple in, I think it was Missouri, who were faced with the protesters. I mean, it was a mob and they were coming for them and they were out on their lawn and protecting themselves. And that's one thing you learn in gun training, is that you can't like point it at people if they're not an imminent threat. So that's why they got hung up on that. So they weren't, I'm not criticizing them because I would have been terrified in that situation too. And I think that was a selective enforcement because they had political motivation. I don't think they should have been charged. And I think it's, a miscarriage of justice. But it just goes to show you that, where David Gregory can go on national television and show a 30-round magazine, no prosecution, and yet these people are in fear of their lives and they're being prosecuted for it. So I think, getting to your point, the Supreme Court has held that it's the firearms that are traditionally used for lawful purposes. No one's talking about F-15s. And I think the response to people who say that is just like, you're just crazy. Like, you don't even want to engage in a realistic discussion about this because you're just, kind of typical for Biden. He's just out in space, so it's not really a surprise. But if anyone else says that, there was a really funny Twitter. I can't remember who did it. Maybe it was Carol somebody, but she got into a fight with Piers Morgan, I think, on Twitter, and he was saying something about the Second Amendment should only protect muskets, and she responded something about, no, it protects something else, and he said, where does it say that in the Second Amendment? And she said, right next to muskets, right next to where it says muskets. So, if anyone talks to you about that, it's like the Supreme Court said what's traditionally used for lawful purposes, and the AR-15 certainly meets that because they're over 3 million. They're probably a lot more. As we have Democrat presidents, they're like the number one marketers for firearms because everyone gets freaked out. And you see all the chaos. I mean, the chaos we had last summer, the chaos we might have had in the fall if the election had gone the other way, and people they just want to live their lives, but they want to defend their families. So the F-15 and any crazy things like that, it should just be muskets. That's just absurd, and I wouldn't even talk to people like that. I mean, I talk to them, but not about that issue. Yes, what is your name?
My name's Ashley.
Ashley, nice to meet you.
Nice to meet you. Thank you for speaking to us.
I'm so happy to be here.
So one of the most common arguments I've heard from the left regarding the Second Amendment is that the Constitution is a living document and it's subject to change, and the change is pretty arbitrary. So my question is kind of twofold. One, where do you think this kind of idea that the Constitution is a living document, where do you think that's coming from? And two, what would your response be to someone who says that?
Oh, I love that question. That's my lawyer self thinking about the political philosophy of how we set up our government with the consent of the governed. And I've had many opportunities to go on NPR and be like the one conservative voice, which I really relish and enjoy. And I always have to think about, okay, who's listening to this on the other side, and what can I say that might make them think just a second to challenge their opinion. So if I were going on NPR and someone brought up the living Constitution, I would say, well, the problem is the process. So the way that our system is set up is that we have voters who elect legislators who pass laws, and then the courts review them to make sure that they don't infringe on our rights. So you look at the Constitution, the Second Amendment is an enumerated right, meaning it's one that's actually spelled out in the black letter of the law. And so the role of the courts is to protect these rights against the intrusion of the majority. And that goes for every American citizen. It's a benefit for every American citizen. And the reason that leftists and liberals like the idea of the living Constitution is because they want to shortchange that process. So they don't want to protect the rights that are enumerated in the Constitution, and instead what they want to do is they don't want to have to go through the democratic process. And we've seen this with, a lot of different issues where they tried at the local level to get laws passed that were in conformity with their political ideology or wish list, failed. So they keep taking it to the courts, and they never give up. And it ratchets left. And so what I would say to someone discussing this issue about the living Constitution, you're afraid that your ideas are not any good because you're not willing to persuade your fellow Americans. You need the courts to step in and use judicial fiat to make America the way you want it to be. And that's not our system, and it's not good. We have a process for putting your ideas into place, and it's better. Justice Scalia was a conservative, but he was also an originalist. So when I was doing a lot of media for Justice Kavanaugh, when he was nominated for the Supreme Court before he was Justice Kavanaugh, I would go on a lot of conservative radio shows, and they'd say, isn't it great that we have Judge Kavanaugh, he's conservative, this is going to be great. And I would say, conservatives don't want conservative justices. They want originalist justices, because we don't want it to be the views of 5 people on the Supreme Court. We want it to be principled. We want it to be constitutional, because we love this system of government, and we think it, has its flaws, but it's the best system of government. So I always remember this story about Justice Scalia. He was giving a talk somewhere. So he was very conservative, personal life, politically, everything. But he was an originalist, so he wasn't going to put his personal policy preferences onto the Supreme Court, right? So he said that they should give every judge a stamp that had written on it, and they could stamp the cases. It said, stupid but constitutional. And so I think, for a lot of people, it's like, if you want a living document, you lose the entire point of our system, because you need to be able to have laws that are stupid but constitutional. And so when you have a living Constitution that kills, like I was saying, they want to kill parts of the Constitution, they want to kill the Second Amendment, and they want to invent stuff, then it's a disservice to all of us. So that was a very long answer, but I really love that question. Thank you very much. Ashley, right?
Yes.
Great. Anybody else?
I think we're about wrapped up on our time. ton. But a last question I'd like to ask is, what books do you recommend in general for conservative young women to read, and then just what on this topic would you recommend?
Oh my gosh, I am such a reader. I love books, and my dream in life is to have a room that's just like a library that I can just go live in all the time. But that won't happen because, I have a life. But so I can't give you any great recommendations on books other than, for example, read all the time, read broadly, and read things that really interest you. So right now I'm reading a book by Paul Johnson, who was a British historian, and the book is called Intellectuals. And I'm at the beginning of the book, and he's talking about Jean-Jacques Rousseau, who is a very famous political philosopher. Did you know that he had 5 children, that he had his mistress or his live-in, I don't know, maybe they ended up getting married. He would have her, she'd give birth to his child, and she would, on his order, take the child to the orphanage and leave it at the orphanage. Do you ever hear this in school when you learn about Jean-Jacques Rousseau? So I'm 49 years old. The first time I'm hearing about this is age 49. I thought, why does anyone pay any attention to what he said about anything? Not only did he abandon 5 children, but he made the mother of the child, go give up the child. And I thought, I just was interested in that. So that, I think, read things that interest you, and then you can pick up little details like that. And then now I understand, his whole political philosophy was the state as parent, which is completely against my political philosophy. And now I realize, he was a real scumbag. So, thank you.
We had a little something for you here. I wanted to thank you so much. What a wonderful, rich talk.
Thank you so much for having me.
Well, all of our summer interns were at the gun range, a big chunk of yesterday.
Did you enjoy it?
Yeah. Yay. Learning
Field
safety.
trip.
For some, learning to shoot for the first time. For others, practicing, because we know that guns are the equalizer for women. I've always felt that one of the biggest challenges in this issue, and you covered it, is that our schools don't teach enough about the founding documents. The Declaration of Independence talks about our Creator endowing all Americans with unalienable rights. That means they cannot be taken away from you. And what could be more clear than the wording in the Second Amendment? It's government's job to protect those rights.
Exactly.
They come from God.
Right. Before there was government, there were those unalienable rights.
Yes.
That's the whole point.
And we want to give you, this is our latest publication at Clare Boothe Luce Center for Conservative Women. It's a book for parents, for grandparents, for anybody who wants to help guide a young woman in her life to turn out to be a good, strong conservative. You probably could have written it with all your children. But
I have 4 boys. Out of 2 girls, 4 boys.
You're guaranteed a place in heaven if you've raised 3 boys.
Thank
or
you.
More, yeah.
I'll take it.
Yeah. But this was just published this week by Regnery Publishing.
Congratulations.
Thank you.
That's so exciting.
Thank you so much. And I wanted to mention the first chapter here. Self-worth flows from God, not government. And we're going to do a little sneak preview and put the first chapter on our website, so hopefully people will read that and want to read the rest of it. But we're just so grateful to you for all your good work, and give you this inscribed copy with our thanks.
Thank you.
For
I love
everything.
it. I know there are a lot of moms who, and dads too, actually, who need this information, because I think every year it gets harder. Because it seems like the entire culture, media, Hollywood, schools, academia, everything is allied
Social
against
media.
us. Yeah, social media.
It used to be if your family was conservative and you took your girls to church, you could pretty much count on her being sort of by osmosis, being conservative.
Yes.
But it's not that way anymore, because the cultural factors are just terrifyingly strong. And so what I try to suggest in here is that parents need to start when girls are young, opening the world to them, not preaching to them, not pounding on them, but showing them the conservative principles and how they work in life, and and spending years doing it. The dinner table, I'm a big fan of the dinner table. I bet you
Yes.
you have a lot of dinner table conversations.
Yes, and having those difficult conversations.
Yes.
So, being
Right.
open to
Right.
discussing things that are challenging and things that you might not want to discuss as a parent.
Right.
But if you don't discuss it,
That's
someone
right.
else is
There'll
discussing.
be a void. And giving young women an opportunity to start to express themselves, even at a very young age. So by the time they get to college or even high school for some, where it's so crazy left wing, they're ready for it. They're ready
Yes,
for
yeah,
it.
we need warriors. So
Happy warriors. That's
Yes.
what we conservative
Happy
women are.
warriors, exactly.
Thank you
Thank
again.
you so much.
Wonderful talk.
Thank you.